Happy Friday to ya. Happy Friday. Hey, everybody. Hello, hello, hello. So, before we get out the door, before we go to our seats, first let me make sure everybody can hear me because I don't want to do this twice. Can you all hear me? Can you all hear moi? Just checking first. Oh, hey, Courtney. Good to see you. Hi, friends. Okay, Sherry says yes. All right. So, you guys, I don't know if she's going to be in here today. I hope she is because we miss her. But you guys, please help me in wishing our lovely QB a happy birthday today. I'm hoping she'll pop in maybe at some point today. Life has been busy for her, so that's why she's not been around. But today is her birthday. Let me say hey to everybody, and then I will sing her a happy birthday. Hey, Margaret. Margaret's like, hurry up before I go back to bed. Hey, Morgana. Hey, Patricia. Hey, y'all. Glad you're covering this. Was going to watch. I heard it's good. Yeah. It's so good. Hey, Sherry. Hello, hello, hello. Hey, Henny. Good to see you. I'm glad you're back with us, ma'am. Courtney, good to have you over here. Hello and welcome. Let me see. All right. Good morning, Gail. Hello. All right. So, whenever QB decides to pop in, maybe if she watches the replay, I'm going to sing our happy birthday. Happy birthday to you. Happy birthday to you. Happy birthday, sweet QB. Happy birthday to you. And many more on Channel 4. Scooby-Doo on Channel 2. And all the rest on CBS. And hold on, let me think of another one that we can start using. I don't know. Is their birthday end in a 6? Because then we could say something, rhyme it with Netflix. Margaret, make it a rhyme real quick. Make something so we can use the word Netflix. Oh, thank you, Patricia. Come on, Margaret, spit something out so I can sing the ending something rhyme with Netflix. Margaret is our in-house poet. Oh, wow. I didn't even know that was a thing. Patricia said I was watching the Hollywood Squares reboot last night, and it just made me miss the 90s even more. Didn't even know that was a thing. Yeah, make sure to hit the thumbs up when you come on in, but put your gloves on because people in here has been sick. We don't want no more sickness. All right. So, you guys, let me just say that the last Kohberger judge, Judge John Judge, nice guy. He's a nice guy. A little too nice, if you ask me. And I've heard from this judge, his name is Judge Hippler, I think. And I've seen him here and there in different things. Much different judge. But I saw him last night. So yesterday they had a Kohberger hearing. There was a hearing. They wanted to argue a couple of things, right? They want to suppress the, what do they call it? IGG, which is the investigative genealogy something or other. And they're saying that the FBI got it, the dad's information. Oh, she said, I'll run Netflix later. I'm on the phone. Okay, Margaret. But they got it in a not professional manner, I guess. So basically, the data banks like 23andMe or Ancestry.com, those kind of things, there is a policy that says that the FBI or government agencies are not supposed to use it for that purpose. But whenever they were looking for DNA to confirm, they couldn't find what they needed, and they ended up going that route, even though policy-wise they weren't supposed to. Now, they're saying that it's against Kohberger's constitutional rights, and the prosecution is saying, just because they went against policy, terms of service, blah, 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 that doesn't mean that it violates his constitutional Fourth Amendment right. So they were arguing yesterday over that, right? And this judge is not playing. Ann Taylor usually runs the courtroom, okay? Usually, when the clock strikes 6, we'll watch Netflix. There you go, Patricia. I like it. Seriously, though, QB, when and if you watch this, happy birthday. I love you, Bryan. Gail, that's awesome. Gail says, my devotional this morning was about fellowship and community, and my mind went to this group. Aww. Love you, Jenny, and everyone in this group. Oh, I love it. That makes me happy. That makes my heart happy. Morgana says, Margaret, hang up the phone. This is more important. When the clock strikes 6, we'll watch Netflix. You're not over the hill. You can still Netflix and chill. I like that one too. That's cute. You guys, last night we had pizza for dinner, and Dale put extra cheese and pepperoni on top, and that was good, right, Patricia? Yours was too. I like it. I'm not good like on a whim, like that. But he put extra cheese on, and I took a bite, and the sauce under the cheese was still like piping hot. And now that little like, that little, I don't. There's a word for it. Somebody mentioned it a while back. I can't remember what the word is called. But it's this little piece of like skin behind your two front teeth. And every time I eat like pizza rolls or, hot pockets or stuff like that I can't let cool down, I always end up burning that, and then it like separates and it's like flops and I have to like pull it off, and now it's like sore, hurts. Do y'all ever do that, or is it just me? Now I'm embarrassed because I think I'm the only weird one on the planet that does that. And so now every time I take a drink of my coffee, it stings. It hurts. Just me, says Margaret. That's not fair, Margaret. I just call it my doogie flotchy. I don't know what else to call that little dangly bit. I'm the first person in the whole United States of America that's ever done that. Ah. Gail said yes, fried mushrooms get me too. That sounds yummy though. I thought of that word, Morgana. That's the word I thought of, and you taught me that word. I don't know what it's called. I do know it's not the weenus. Yeah, the weenus is what is it? The inner part of your elbow or something similar. It's called pizza burn. Margaret is sassy today. She got out of the whole bed on the right side even and put her sassy pants on. She put her sassy britches on today. She did. She got her sassy pants on. She sure does. Oh, it's the loose skin on the outer elbow. Okay, okay. Well, I had elbow right. Mm-mm-mm. It's the weenus. My weenus is dry. I need to put some lotion on my weenus. Oh. Hmm. Margaret's not had coffee yet. That explains it, Patricia, right? Get back in bed and get out on the other side. Mm. She's being sassy. Sassy, sassy. Margaret, does your weenus need lotion? Patricia, this is a family program. A family program. True, it is. Morgana's weenus is saggy. Hate saggy weenuses. All right. Hey, Tanika. Tanika comes in. She's like, yes, this is a family program. Member for 5 months. 5 months. Thank you, Tanika. This is my fave. I love that. Love it. Good to see you. How's things going? It also says vagina is the other. No way. Oh my goodness, Tanika. Ma'am. No way, Gail. It can't be right. Tanika gifted 10 Crime Cafe memberships. Look at that. Ma'am, you're too kind. You are way too kind. Thank you so much. I need to know who got them. I have to go to my YouTube to look to see because it don't show me on StreamYard. Yes, that's amazing, Tanika. Thank you. That's so sweet. We still need to chat. I sent you a message on IG the other day. Tanika, let me give you some more sparkle. Sparkle Man. Sparkle Man. Thank you so much. I need to go see who got them. Hold on a minute. Hold on a minute. Wait, what? They're making communities now on YouTube. Is that just me? Has anybody else seen that? Or is it just the regular community section? I'm confused. Maybe that's what it is. Maybe I'm just confused. I thought they were making. Sorry, I saw something on YouTube. Never mind. Don't. Just ignore me. Just ignore me. Ignore me. Tanika says, I'll look. I have to stay off IG. My bank account cries when I'm on there. Yeah. I know. Ooh, what? You're so sweet, Tanika. I watched your video the other day about the AirTag testimony. Very interesting. What? AirTag testimony? What? That sister is sus to me, that whole family, really. Now you got me interested. Um, what was I doing? I got on YouTube to do. Oh, I know what I got. I got on YouTube. See, I lost my whole thought process. I got on the YouTube to go to my channel to see who got those memberships. Lord have mercy. I can't concentrate for 2 seconds. Gail got one. Amanda Page. Sharon. Mo got one. Holly. Kim. Rise of Phoenix. Michelle DeMattis got one. Proud mom of Tater. That's cute. Mel. Very cool. Thank you so much. Margaret said, while we're ignoring Jenny, please remember to like, share, subscribe, and thumbs up. You're such a brat. You are such a brat. All right, let's get back to the topic. Bryan Kohberger, the judge, more than anything. So what I was saying a while ago, before we started talking about dry weenuses and things like that, is, I lost a fingernail. I gotta put it back on here in a little bit. I've got it laying over there on my desk. The Ann Taylor usually runs the show in these hearings and stuff, right? She usually runs the show. Judge John Judge allowed her to, and the guy with the long beard, right? For the prosecution. But this judge is not having it. He's not playing. He's like, no, no. And I like to see it because this isn't some willy-nilly little, like, fender bender case, right? This is 4 college students with the whole rest of their lives to live who were brutally taken off this earth. And it just blows my mind. Hey, Caroline, good to see you. Thank you, Tanika. Thank you. I appreciate it. I don't wear makeup often enough. I go in spurts. I wear it, a few days, and then I won't wear it for a few months, and then I'll wear it for a few days, and But the yesterday they had scheduled Thursday and Friday, yesterday and today, to have 2 days worth of hearings. The trial is set to start in August of this year. So that's like, what, we're January, February, March, April, May, June, July, 7 months from now. And this is going to be a big, long trial because of all of the evidence, for one. 4 victims, right? And I'm sure tons and tons and tons of expert witness testimony. So, yesterday when they started where's it at? Was this the day? Yes, this is the day. This is the day that the Lord hath made, that the Lord hath made. We will rejoice. Sorry. We will rejoice and be glad in it. Present, share screen. Where did you go? Which one is it? This one or is the other one? I think it's this one. Yes, this is it. So if you watched any of this hearing yesterday, you will know that, oh, well, you can't see it. Hold on. You will know that it was an 8-hour long stream, okay? 8 hours. Says it right there on the screen. 8 hours. The first 5 hours and 20 minutes of it was that screen, or a screen similar to that says the public portion of the hearing will begin shortly, or this portion of the stream is not open to public, blah, blah, blah. So they have like massive, I guess, I don't know, is it a gag order? Do they still have, is this case one that's got I think so. There's like a gag. They won't let nothing out. No pieces of anything hardly out. And so anytime they have a hearing, I'm always like listening for any information that we can get because, and I will say that there was some stuff that they talked about that I was like, whoa, really? What? Patricia said I got my portal potty privileges back. Yay. Yay. By the way, Lori Vallow Daybell, the word is prejudice, not prejudice. If you know, you know. Put a 1 in the chat if you know what I'm talking about right now. Lori Vallow Daybell. She wrote her own motion for something. I don't remember what. I think motion to dismiss. Something to do with speedy trial or something yesterday. I think I saw it. And I thought maybe it was just an accident that she wrote. It was handwritten by Lori because, she's representing herself. But she wrote it more than once the same way. I'm like, what? It's prejudice. Prejudice. Not prejudice. She spelled it Pred a few times. And I think she also spelled the word extradited wrong. And she misspelled the word defendant once. She put the wrong date. She put November of 2025. And it was the wrong date. November 2025 hasn't even happened yet. So, there we go. Back to the whole portal potty. She can see into the future and all that. Whatever. She's crazy pants. But yeah, she if you can't spell the word prejudice correctly, you should not be representing yourself. No. The public portion of the hearing will begin shortly. So they started this, and finally, I kept checking in and off and on throughout the day, and I was like, when are they going to show anything? And then I scrolling on the river, and finally got to this part right here, and finally they started. And I wanted to watch this with you guys because straight out of the gate, they have been arguing all day. At this point, they've been arguing about 5 hours and 20 minutes, give or take a lunch break and a comfort break here and there. And they straight out of the gate, you can tell that the judge rattles Ann Taylor, which I like to see. Because prior, Ann Taylor rattled the other judge. And I've said it multiple times, and I'm going to say it again. I'm so glad that, I'm sure Judge is a fine judge, but not for this case. No. This case deserves a judge that runs his courtroom and doesn't let the attorneys run him. But I wanted to watch some of this with you guys. And they're back today. I've been listening to it this morning, and they're back today arguing more about getting some DNA evidence thrown out. And some warrant things. Patricia said it's so ironic that she was the one who wanted to change a venue, and it got her involved with a judge that she can't walk all over. Right? right? I mean, don't get me wrong. The judge gives the prosecution just as much, uh, you know, is guff the right word? What's the definition of the word guff? Is that the right word? Guff? What does that even mean? Hold on, let me Google it. No, that's not the word I'm looking for. But you know what I'm trying to say. He gives the prosecution just as much whatever word I'm looking for as he does the defense. So he doesn't, like, he's not biased. You can tell he's not biased, I think. I mean, he shouldn't be anyway, right? But, I mean, then you have Judge Gull and Judge Bev and... So we'll start. But like I said, I love this first couple minutes. I was like, yes, because they come out of their break and listen to this.
Are we ready to go live? All right, go ahead.
Again, this was yesterday.
All right. We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming. For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Franks motions filed by the defense that will include the Franks hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Franks issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Franks next.
I did not. I apologize. Yeah.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Franks items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Okay, so in case you missed that, I'm going to watch it again because I want you guys to pay attention to her facial expression and the like under the desk hand motion that she does to the gal next to her. So they come out of the break and Ann Taylor thinks that she's going to argue this suppression of the IGG DNA stuff, and the judge thinks that she's going to argue the Franks motion, which has to do with the probable cause stuff where they got their search warrants and how they got their search warrants and all that kind of stuff, right? And yeah, they were not on the same page. And she's like, when he said going to argue the Frank's motion, she was like, watch her face. I'm going to rewind it back. She puts her hand down on the desk, under the desk, and is probably like, doing this number to the gal next to her, like, oh my God, what do I do? What do I do? What do I do? It was pretty funny. I'm not even going to lie. Hold on. I got to get my tabs in order here. I got tabs open that I need to scooch out of the way because I'm getting confused on where I'm at. Let's start this over and watch this part again.
Are we ready to go live? All right, go ahead.
Okay, now watch. Whenever he says this about arguing the Frank's motion, look at Ann Taylor's face. And for those of you that aren't sure, Ann Taylor is the blonde-headed, sitting on the top left quadrant of the screen.
Let me know when we're ready, Sandra. Ready? All right.
She's got a fistful of papers to go for the whole IG thing, right? IGG thing. And,
We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming. For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Frank's motions filed by the defense.
did you see her face? She went. Watch her face one more time.
We are now going to hear argument from the parties on the Frank's motions filed by the defense. That will include the Frank's
Now watch.
hearing.
She'll put her hand down under the desk.
That was held on the IG.
And the attorney to her right, that's sitting there in the middle with the dark hair here, she's also like, wait, what?
IG issue, as well as the defense's proffer as to the rest of the Frank's issues
put her
as to
hand
why
down.
the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well,
Hey, Kel.
the
Good to see you,
suppression
doll.
IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Frank's next.
I did not. I apologize. Yeah.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then
He's like, okay, I'm glad that you need 5 minutes, but we're going to go on with the first thing first because we've been here all day, okay? And we're going to get on and with this. We're going to get on with this.
then we can then hear the Frank stuff. That's fine. If that's
He
what you're
does give her
prepared
the
to
5-minute
argue.
break here in a few
you.
minutes, though.
Go ahead.
But now I want you guys to be prepared for this argument that she's got, and I can't wait to hear what your thoughts are. Because I had to listen to this a couple times last night to wrap my head around what she was really saying. But it makes sense, but it also doesn't. You know what I mean? So it's a really good argument, though.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is
And just so you're aware of what she's talking about the IGG is the investigative something genealogy. And that those are it has to do with the data banks where, like Ancestry.com, one, is it 23andMe? There's a few of them out there, right? Well, if you remember, the only reason they got Bryan Kohberger's DNA match with on the knife sheath was because they got trash out of his parents' trash can, and they found through one of those database websites that he was the dad to Bryan Kohberger, okay? And so she's going to argue privacy things. But that's what they're talking about as far as the genealogy and the DNA and stuff.
Is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given. And
now, I don't know about the other two stages, but the one stage where the police get the trash from the trash can, it's common knowledge that once that trash can hits the street and is ready for pickup, it's public access. You don't have to have a warrant to go through the trash. Right? Exactly, Tanika. No expectations of privacy in the trash. Once it hits the curb, it's public. Yes. And they tried to act like it was being wishy-washy, but they've got video surveillance body cam footage when they went to get that, because it was a whole thing that they, when they went to get that trash can, they were surveilling the Kohberger's Bryan Kohberger's parents' house and Kohberger. And they, I don't think, would have done anything to risk that. You know what I'm saying? I mean, I don't know, but that's like public knowledge. Now, she does have an argument that she talks about here in a little bit about why it's still against his privacy, something to do with a rule about who's able to touch it, the trash, once it hits the curb. I don't know what she's talking about, but anyway, I think that she's grasping at straws.
And so this must be suppressed. Your Honor, I'd like to identify the three stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed.
I know, that cracks
Your
me
Honor-
up. That cracks me up, Patricia, because she calls it genealogy. I've never heard anybody in my life call it genealogy. She's the only person that I've heard say that. And I thought the first time she said it, I thought she was like saying, like accidentally said it wrong. But then she continues to call it genealogy. I'm like, what in the world?
For the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife
No,
sheet.
I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA.
Hey, Miss King.
But those databases don't churn out a name and say this is
I have
our
a privacy
suspect.
interest against any of my relatives that might want to upload their DNA to one of those
Good question.
systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
Exactly, Miss King. Yes. Yes. I think this defense team is wishing they did not ask for a venue change. This judge knows his stuff and makes decisions, unlike Judge, who did not. 100%. 100%. That's what we were talking about at the very beginning of the stream. Well, that's why I put in the title, this judge ain't playing. He's not playing no games. I like him. I do too, Tanika. I like this judge a lot.
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position,
I agree. That part is an assumption. In my hypothetical, I said my DNA that's taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in
outstand when
violation
he's
of his
accused.
rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here,
Hey, Laura.
he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
Okay.
Our first point is it was an illegal.
She's getting mad now. I mean, she's been mad, but these are the things. These are the things I want to talk about now.
Search. And this is if
The search,
the
which
court's
search?
assumption,
Which search? It was illegal.
first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS. Uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret, that happen when there's a portion of the DNA taken and it's searched by Othram to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as asserting family.
Specific DNA tests of the sample that goes from legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
cite to that.
I'm sorry?
Can you give me the cite to the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
Yeah, the sheath was left under the body of Madison on the bed upstairs. What they found in the trash was, there was nothing found in the trash at the house, but the trash that they're talking about here is the trash at the mom and dad's house, which is where they got DNA from Bryan Kohberger's dad. And that's how they matched the DNA from the knife sheath left at the crime scene to Bryan Kohberger, because it matched his dad's. Yeah, she's not being really clear, I know. And as far as a search warrant, they received a 911 call, right? So I don't know you know, I don't know how that process is. I mean, they would have had, a whole chain of custody thing, but yeah, I'm not sure because she's not being super clear. Probably because it's all known information and the public doesn't know everything they know. Yeah, the genealogy too. Yeah. She's saying that there should have been, and she's saying there should have been a search warrant for the search of the what do you call it? Trash can. Sorry, I'm peeling nails off, getting ready to put a new set on. No, don't be quiet, Laura. No, 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 no. No, ma'am. You said you're obsessed with this case, so I'm glad that you're talking. I like for you guys to talk about it. Absolutely.
And I apologize because my memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is 690 F 3rd 226.
Okay. Go ahead.
All right. And so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the
Right, and part of the problem too, Miss King says the judge is saying you don't need a warrant for what other people willingly upload. Right, that's why he was asking the question about, is it violating my rights because, someone else in my ancestry, in my family upload something, right? But she's leaning heavily on the fact that the FBI went into those databases to get information when it's against their policy for FBI to do that for that purpose. And I kind of get that. I get that part of it. And I can see why she would argue that. But then the prosecution is also like, it's their policy, but that's not like, that's not that's not taking away his Fourth Amendment rights. One doesn't equal the other, I guess.
court a little bit about the things that happened in this case that were super secret.
Or
I
one
think we've
doesn't
gotten
make
to
the other
point where
happen.
We were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
It's got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that
Right, Kel. Yeah. There's the phone records. And they also have, unless it's been debunked, I haven't really heard, but they said that there was also one latent shoe print. That I think was on the second floor, which is where Ethan and Xana's room was. And if I'm not mistaken, I think I heard or read that that latent footprint was outside of Dylan Mortenson's bedroom. So I don't know if I've ever heard if that they've, have proven who that footprint belonged to or not, but yeah.
DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
And not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here, and that case was about, third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you
Prints
went.
everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go, you drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches, and that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Why should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple of points on that. First, even assuming that that's all correct and that they violated the terms
Seems to be the evidence.
The terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So, for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain, and certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document, and if you look at the policy in footnote 1, it clearly says, this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say?
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address, the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit.
Okay, just a quick heads up. It is time for her virtual math class. It should be shorter today because it's Friday and they do their reviews or whatever on Fridays. So I should be back quicker than normal. But I will be back. And they argue for a few more minutes and then they give like a 5-minute break before they start the Frank's motion hearing part. Sorry. My nails are driving me crazy because I took my old nails off and I'm getting ready to put new ones on. Anyway. So anyway, that's all I wanted to say. But I will be back momentarily and I will skip through the break if I catch it. If not, it's just a short 5-minute break-ish. But I'll be back in a moment.
It expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found, and they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the U.S. Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the U.S. Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the U.S. Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
Trash company collected it.
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
pulled over after they got out of the neighborhood and said, here's what we grabbed.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that garbage cans were at the end of the driveway, at the end of the property. At the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam. He drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now, it is what it is in this case, and of course complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case, and yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that.
It's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, that you have to put your trash out to. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case that changed them.
How does that change the analysis?
Well, Your Honor, I think that it changes
The
the.
expectation of privacy is lost when you put it in the trash can to be taken away, per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think that there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
Not the case.
Unless
you're saying the Supreme Court was wrong, the Idaho Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything.
But I have to follow what they say.
But I have to make a record when I don't agree.
I appreciate that. I'm just trying to make sure we're talking about the same thing.
And I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do. So I'll move on to something else. I want to talk about now where Mr. Nice started that Department of Justice interim policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider just like you would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do, and that was done twice without a warrant in this case, and there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you. All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally. Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
All right,
different things.
we'll take 5.
Thank you.
All right, let's take up Frank's.
Your Honor, I think on the court's bench, there was a document placed, so
What,
it had initials to
Oh,
comply
thank you.
with the court's.
appreciate it.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on, so.
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
My only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody, they were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed Shortly after 911 was called in the afternoon of November 13th, 2022, and she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. And I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. The next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car. Their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing, and we know what it is that's around this particular area. The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in, I believe, D10. That's in D9. And finally, after several submissions, that's when the FBI IML says I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car, and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court, as it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop, and that's just not what happened. It's pieced together, and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail, that they've picked out a time that something probably happened here, and they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective, and if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No, no.
If it were to have been disclosed, it would have simply created more basis to suspect Mr. Kohberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. Then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front. It wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest, and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that...
Hey, friends, I'm back. Hey, Cherie, good to see you. Let me see. Just making sure I got everything in the chat. So, is anything she's saying making sense to any of you? Anything? don't know. I don't know.
That's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters. Go ahead.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the car, the phone
Hey, Gina.
stops reporting to.
Hey, Gina. Patricia said it sounds like she's saying DNA and most other evidence should not be allowed to be used. Ever. I know, right? It's almost as if she's saying, you know, so that we don't step all over his rights, he should have been like, Here's my DNA. Please use it and test it. You have my permission. That's not going to happen.
To the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to pick a time 7 minutes before it really stopped reporting, and they chose to make a map that showed a direction that that phone wasn't traveling in to create a false narrative for the magistrate to
Yay,
rely
good,
on
Cherie. I
to
wonder
find
how
probable
Michelle's
cause.
husband's feeling today. I haven't seen Michelle. Oh, I do now. Remember, Michelle said yesterday that she wouldn't be here today because her mom had doctor's appointments. So, but Michelle, if you're watching this on a replay, I hope your husband feels better today.
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C.
God love.
That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they
an
don't
apartment?
match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location.
A recap towards the trial. Henny, I mean, I would love to do that. We've talked about this case a few times here. I think I even read the probable cause affidavit. For this one back months and months and months ago. I can't remember if I did or not, but we talked about it a little bit, but I would love to do another, big recap of this.
Moscow has, I think, 2 cell
Before
towers
the
that
trial.
service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side, but then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the CAST draft report and in the CAST final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants
I'm not buying it. I think he's guilty, but
that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car, there's no he wasn't connected to that house, to the people in the house. Your Honor,
Maybe I'm thinking of a different date for the AT&T. I thought, not the cell tower stuff. So you're still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have because that was
I thought you
early.
transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger? Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context, because of the IgG work. Because
I missed that part originally. I did not hear that part. I did not hear that part. Oh my God. Every day and twice on Sunday. Isn't the knife sheath DNA? How did he say that about the enough probable cause? Oh my God. Because she's trying to go and say, there's no shred. He wasn't there. He was, he was in Moscow riding around, but he was nowhere near that house. They don't have any shred of evidence in his car, on his person, in his apartment, blah, blah, blah. And for probable cause. And the judge is like, his DNA is on the knife sheath that was found in the murder house under the victim. That's enough for probable cause. Every day of the week. Twice on Sunday. I love this judge, Gina. Compared to the previous judge before they did the change of venue, that judge, the other judge, he was a nice guy. Too nice of a guy. Like, he needs to be the guy that does the traffic court videos. I forget that guy's name. Hold on a second. I have a husband. Hold on. Okay, so Miss King says, I agree, Judge. Judge was nice but not in control, and I felt the defense walked all over him. I feel the exact same way. I've said it from the beginning when they would have their hearings and stuff. I'm like, no, he does not run his courtroom. What I was saying was, though, I can't remember. What was that judge's name, that the older judge that did the traffic court? I forget. Something, I think he's Italian. He has an Italian. I can't remember. Anyway, that's the kind of Frank. Is that who I'm thinking of? Judge Frank? Who's that? That don't sound right, Henny, does it? Caprio, that's it. Yes. Yes, 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 yes. Judge Frank Caprio, that's him. Yes. You're right. There you go. Caprio. Um Italian last name, yeah. I thought he was Italian. Gina said this judge has some personality and will make it more interesting. I agree. I agree. Yep. Um, well, and he'll make it's more interesting, but in my opinion, whenever you have a judge that just lets the defense or the prosecution or both walk all over you, you let them have control of the courtroom, then I mean, you're supposed to be the umpire or the coach, or not the coach, the referee. You know what I mean? I mean, how's that going to work? That's not going to work. And it's okay if it's, like I said earlier, a fender bender. That's one thing. But not when you have a case like this that is going to. I mean, this trial is going to be one that will be talked about forever and ever and ever and ever and ever. You know what I mean? They all should be, but I'm just saying this has been a very controversial, maybe, kind of, even, if that's a good word. I don't know. It's just, I think this judge that they've got now, this Judge Hippler, he's the right one. And yes, Margaret, I'm sorry. I'm sure you've already rewound it every day of the week and twice on Sunday. But we're going to rewind it and watch it again now. Sorry for that. This was good. I like this.
And what I mean by that is that there's no blood in his car. There's no
He
He
starts
wasn't
talking
connected
here.
to that house, to those.
He's talking here. You can't hear him. It's like his microphone isn't working or something. But you kind of get. He says something about he is connected to that house or something, and she tries to challenge him. Challenge.
To the people in the house. Your Honor, there's no. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car.
Did you see his face shift when she said that? No connection to anybody at 1122 King Road. Watch his face when she says that. I'm sorry, you guys. I am piecing and parting this to death, but I'm excited about this hearing. I can't wait to watch today's. I started it, but then whenever 11:30 came around, I had to get started with you guys. So
His car gets searched again, and his car gets searched again,
look, watch his face when
and
she
there's
says
absolutely no connection between him
And
and
another
anybody from 1122 King.
look at his face.
And what I mean by that is that
He squints his eyes and then he's like rubs his face.
112, absolutely
One
no.
more time.
The
Sorry.
fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I'm thinking of a different date for the AT&T. I thought, not the cell tower stuff. Is that you still talking about the cell tower stuff?
no, I mean, that stuff applies to every single warrant we have because that was
I thought you
early.
transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context because of the IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause.
Is she on substances or something? What? What? I mean, I know she's trying to say, oh, it was already there. But what? And he's like, yeah, especially if you've been killed by a knife. I mean, I feel like she's trying to, I feel like we're playing a game of let's pick the item that does not go here. You know what I'm saying? We have a girl's room with makeup and cute boots. Cute. I think they were cowboy boots in Maddie's room. Cute cowboy boots or cowgirl boots or whatever kind of boots in the window. We have, all these things, all these girly things. And then there's a K-bar knife sheath under the body of someone who's been killed. Two people, two bodies, one on top of the other.
This is not a proof beyond a reasonable doubt standard. It's
Before a jury, what?
and twice on Sunday.
Sorry.
Not in this context. Not in this context because of the IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. There's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about let's just go with the car. Let's just go with,
Okay, for me, I don't care which way the car is pointed. I don't care if there is I no. If there is a knife sheath under a victim on a bed who has been killed and somebody's DNA is on that knife sheath, I don't care what other evidence you have to say that his car was pointing in this direction or that direction or his phone didn't ping over here. I could care less. The DNA and the sheath, all that trumps everything else.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object associated, likely associated with a murder weapon.
Mm-hmm.
I have not yet a magistrate would not find that probable cause.
Right.
the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters, it parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right?
That's all she has is car surveillance, cell phone information. That's pretty much all she has. All she has, in my opinion, that we know of so far, is to go on, is to say that there's no way he could have been there because blah, blah, blah. Because of this footage. Because of these pings. Because of this whatever. That's all. That's it. But there's way more to suggest that he was there. I mean, they say they have proof. Prosecution says they've got proof that he drove up and down their road 3 times.
13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would trump.
He used the
would
word trump.
cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA,
That's kind of it.
it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they
good
just
luck
build
with
on
that,
each
honey.
other.
Good luck
So
with that.
you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway, because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved, if you assume that that blood was related to the victims and not some earlier event in the house.
What?
Do you realize the amount of kids that were in and out of that house? That house was known as a party house. Now, you tell me that they're not going to find all kinds of unknown DNA inside that house, including blood. I mean, yeah, it's a little shady, but the blood was found on a handrail, not a knife sheath under a dead body. You know? One thing that's the same as another thing. Right? Can you stop talking in code, lady? I'm lost. Yeah. What she's saying is that on the probable cause affidavit, why do they only get to say, oh, well, the only thing that's probable cause is this knife sheath with his DNA on it, when there's also evidence that shows that there's unknown DNA from blood on a handrail. So why is that not considered probable cause? That's what she's saying. And he's basically said, well, I mean, it could be if you want to say that maybe Kohberger had a kill buddy with him, you know.
What the court is saying is exactly why the magistrate needed to know that.
Noise
Is
complaints.
there another
Lots of noise complaints. Multiple noise complaints. And they had even had a party, I think, what was it, the night before this happened? And the night that this happened, they had been to parties. Not all of them, I don't think, but I think, yeah, I don't know.
explanation here. I've got this sheath, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know.
Now, I did hear about the glove. I did hear something about that. Blood on a glove. blood on a glove. But I think someone had said, had speculated that that may have been like from one of the investigators or somebody that worked the crime scene, may have, I don't know. I don't know. That was a little weird. And I do know too, they said, I think, that there was like a bag of trash that was outside the back kitchen door, the sliding glass door, that was never collected. Like, police never took it or so. I find that really hard to believe. I mean, I guess, I don't know if it was like a trash can that was open or if it was like a trash bag that they had just set outside, tied it up, gotten a full trash can in the kitchen, pulled it out, tied it up, and set it out the back door to be hauled off later or whatever. I don't know. If that's the case, I could see them not really checking it. I mean, I would still think that they would check it, but it would be less likely to have any sort of evidence against, Kohberger or whoever did this, because it would have already been tied up and put outside, But what crazy person? I know that there was no blood of his found in his car or outside. I find that hard to believe. Not his blood, but any of the victim's blood found outside, or in his car. But I think he was just meticulous, and I think he probably had one of those, like, what do you call it? Like overhaul suspenders or something on that kept him clean, and he put it all in a bag and disposed of it between there and his home.
What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it.
No.
I think the purpose of Frank's is to ask this very question. This is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Okay, so let's never again, let's just ignore the fact that there's male DNA on this knife sheath that's found under Madison Mogan's body. Let's just ignore that. That's not probable cause. No.
The Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie.
No,
to the
Henny, he didn't.
For purposes of probable cause.
He didn't, because Dylan Mortensen, the living victim, one of the living, he never attacked Dylan Mortensen, the female on the second floor that heard things. She saw him walk by her, and she's the one that described his bushy eyebrows. He had on a mask, but she saw bushy eyebrows. But she saw him leave Ethan and Xana's room, where Ethan and Xana were, and then walked past her. He didn't even see her, in my opinion, because she didn't say anything. She said she was just standing in a frozen shock phase, and he walked straight out the kitchen and out the sliding glass doors, and she shut the door and locked it. And I would love to know what happened, but that's another story for another day.
This isn't for purposes of conviction. For purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that create concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable causes. Mr. Kohberger, if his DNA is found on a knife she found on or near the victim, who was stabbed with said alleged knife that would have been in said alleged sheath.
I think
Checkmate.
the most
Checkmate.
prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the
She's
witness
dreaming.
who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this when they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, et cetera, right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions, yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
I think, now, Mr. Mayor, we're going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right.
So, I think she just finally kind of hit the end of her rope. She's like, okay, this is it. I'm done. I don't have anything else. I'm out of gas. I'm out of steam. I have nothing else to offer. So,
Go ahead.
Gonna attempt. Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits
and you'll see too, that, and this is another reason why I love this judge. I mean, he's not just hard on the defense. I mean, he's just as hard on the prosecution. I mean, he doesn't let anything slip. So,
and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause. That they were the basis, which were the basis for multiple search warrant applications. That within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence, or Scrivener's errors, or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved
Margaret.
in this investigation.
Yeah,
from
you have no
multiple
takers,
agencies.
ma'am. No takers.
And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission, as Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede, I think there's an issue there. But that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit It wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding CAST. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around King Road residents. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAST work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them into their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved as a Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead it's just a reflection. The work was done by Balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is correct.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed their Frank's motion.
What specifically?
That there are 3 towers.
I believe I referenced it in my response.
Yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the when the murders took place?
Both.
Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only invisible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
Is it also important to establish the timeline?
It is. It's important to establish the timeline, to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And
You all do realize the amount of evidence that they have in this case. Like what we've heard, she describes DM, which is Dylan Mortensen, describes him as slender, athletic, wearing all black, bushy eyebrows. And like I just hear her talking, this is the prosecutor talking, and I'm like, God, I wish I knew everything she knows. Like, I'm that person. I'm that personality type that when I hear a story, I want to know all the nitty-gritty details of that story. Like, I want to know all the details. Like fine-tooth comb details. I'm that person.
And even if the state's wrong, that somehow there was some
To be a fly on the wall in the prosecutor's
relevance
office, right?
to some of her statements not being included in the probable cause affidavit. You can take all of it out, and the magistrate would still have probable cause. The second issue, the second kind of bucket they take issue with DM, is about these other just statements that she gives during interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist's direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second-guessing a vehicle specialist's opinion, and they haven't made a substantial or sufficient proffer for you to do that. Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that well, I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No. Nor did we need to. Really, the IGG has been discussed extensively. I think the only real Franks issue is, should the IGG process the fact that it was not included in the PC, is that the basis for a Frank's hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. We're told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IgG and the use of IgG is only inculpatory. And the non-reliance on the IgG information does not diminish probable cause. And the IgG information was confirmed through the STR testing. I can't wrap my head around any argument that IgG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking, and that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing. And the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located, and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Before we get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's
Detective Payne? Or by a
the
cast
information that he was given from.
member? This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Little, briefly?
I'll try.
I'll try to do my part to make you, so that you can and avoid asking questions unless I'm truly stumped.
Before I get started on what I want to tell you, in response to what the state said and in my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to your honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good, because it occurred after my Frank's briefing came, so I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas, and yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information, and we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us, and that's kind of gotten to be.
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor, and the return on the search warrant says that they already produced them pursuant to something else, and the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have Frank's hearing to explore what that really is about, if for nothing
The
else.
omission or the misstatement that as it relates to the Amazon warrant.
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process, but for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
I mean, I guess from a Frank's perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It's disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay. I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint, and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the 3rd interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make positive ID on the car.
Where is that in the record?
The 1125 Ridge Road, well, it's in our discovery.
Where's it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you. Is it in the box? It's in one of these stacks. It should be this one. Your Honor, I believe it's on page 17 of the amended memorandum.
That's just the photograph?
Yes.
But not the information that ties that to the Ridge Road camera?
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Oh, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet. That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. What these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your Honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too. To leave just a little out here, to add a little more here, and go get a warrant, and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages.
I don't know why at the very end of this stream, I thought maybe it was my computer, but apparently it's not, because it's doing it now too. Whenever it gets to the very end, that it wants to do this spinny wheel. Hello, let me be frank with you. Hello, hello.
That we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
All right, I will take the GEG under advisement. I will under advisement, issue opinions on those forthwith. We will pick up tomorrow with, I'm trying to think, we're probably at the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right, I'll see you in the morning.
All right. So, I wanted to go into today's hearing, but I don't know. Are they still live? Let me open this up in a new tab. Hold on just a second, folks. I want to see
He was hip-hop's biggest mogul, the man
how long their hearing today was. Okay, so it looks like they have 2 streams. What was this one?
was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage.
This was one they had via Zoom. I don't want to see that one. Let me go back to this one. We'll start. It's part 1. It says it's 2 hours long. Hold on. Okay. Let me share this tab. Right. Let me be frank. We were watching yesterday's. But I had today's up because I was watching it earlier this morning. But then when I started today's stream, we watched yesterday's because I hadn't watched it with my crew yet. And then I wanted to start today's. But it looks like Law and Crime broke it up into 2 parts. Court will begin. Is it boring? Well, yesterday wasn't boring, that's for sure. We'll see.
Your Honor. First,
Hang on a second.
oh, sorry.
I haven't called us to order
Oh,
yet.
I am so sorry. I thought you said, sorry.
Said, let's bring the public in.
Okay.
I appreciate the eagerness, though. All right, are we broadcasting, Sandra? All right, this is continued hearing in State v. Kohberger, CR 0124316665. Defendant is again present with counsel Ms. Taylor and Ms. Massoff. The state is present, represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. This morning's hearing will discuss the motions to suppress and any evidence related thereto, as well as we'll get into the argument on that. So with that, I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have 2.
All right, who's your first witness?
Corporal Brett Payne.
All right, let's get going with that then. If Corporal Payne would step forward. You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Good morning.
Morning, ma'am.
Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the Detective Corporal for Moscow Police Department.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the Military Police Corps.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Directly, it's the teams that were assigned to various tasks, and then take in all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right, and Judge, I have paper exhibits for you and for the witness, and so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am, I don't believe I had.
And so, given that, who did you rely on in creating the warrant for
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you
Yeah, if it's going to be a lot of phone record stuff, I can see how it would be tedious.
co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing
Not up close, but from a distance, the guy on the stand, this witness dude, kind of gives me Chris Daughtry vibes. Sorry.
AT&T records, having any access to AT&T records without a warrant?
I'm not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm going to begin with what is known as State's Exhibit 1, attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as State's S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, State's S1 affidavit for search warrant.
And now I've got to get,
Objection to the admission of that for today's hearing.
you know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
But we do need the formality of moving for the admission, however. So that's why-
I can do that. Do you want me to do that per
sweet
exhibit?
Donnie.
Well, it makes, if you, as you're talking about them, it probably makes
Hi,
sense.
Donnie.
Okay, I've got to get myself S1.
Good to see you.
Okay, Detective Payne, can you look at page 5?
Yes, ma'am?
On page 5, can you read what it says in the, at the very end of the page, in the sentence above wherefore that begins with,
Hello?
the paragraph, it begins in support. Can you read that paragraph?
Certainly.
it
In support of the
me
assertion
you're
as to the existence of
looking
probable
for?
cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and
I can
incorporated
see it
as
in your
though fully set
eyes.
forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
Right, I'm now going to hand you State's Exhibit 2 to the AT&T first warrant.
The yawns are starting to set in, folks.
Can you review that first page, the first paragraph?
Donnie, that's me all the time. That's me all the time.
Admission of S2.
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
No objection to S2? All right, it's admitted.
Have you reviewed that, Detective Payne? Do you see that, the
know,
language
right,
that I just
Donnie?
referred to in
Yeah.
the search warrant affidavit? Do you see that same language in this warrant in, where you incorporate the affidavit, incorporate Exhibit A into your, you see that language
Ma'am.
in S2? And is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T Mobility Propriety front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just to,
Donnie, it's somebody from the Moscow police department. He's talking about the phone records from AT&T for Bryan Kohberger. And the one asking questions is one of Bryan Kohberger's defense team.
for purposes of him being able to be certain. Sorry.
The witness may be shown the document to refresh his recollection.
Oh my God, the 3 p.m. yawns are set in.
Yes, ma'am.
They've set in hardcore.
And Judge,
I'm
for the
gonna have
record,
to-
this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's,
15:31.
okay, thank you.
I didn't know what her name was. Frank, thank you.
I'm now handing you Defense Exhibit A to the reply to the AT&T suppression motion.
This doesn't have a sticker on it?
Pardon?
This does not appear to have a sticker on it.
No, it does not, but it is attached to the reply as Exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T?
So this is the return of the warrant of S2?
Yes.
All right, let's call it S2.2. Or 2.1, pardon me.
That's fine.
The fact that it's associated with that particular warrant. Allowed to touch stickers under the union contract, so why don't you give it to the bailiff?
Yeah, I have. I talked to her, Donnie. She's got. Today's her birthday.
Detective Payne, on page 2 of that Exhibit A, it's actually, Just the front page where it says affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4?
Line, well, 1, 2, line 4.
It's her birthday.
Says the warrant was served on 12/23/2022 by email, fax, et cetera.
So do you know exactly what method was used?
I don't remember.
Okay, and it says warrant in that line, right?
Yes, ma'am.
Does it say anything about the affidavit in support of search warrant accompanying the warrant?
Hello, Infinity. Welcome.
On the next
Yeah,
page,
she's been super busy
the
with
receipt and
life,
inventory
life.
of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Was there anybody else that you relied on for that other than Special Agent Balance?
Not that memory brings to mind.
Okay. Let's now turn to the AT&T2 pen trap, and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So pen register, best of my knowledge, now granted I am, as I've stated before, I'm not an expert in cell phone stuff, but to the best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located when it was doing it.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities, because that's all I really know?
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pen trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03,
Yes, ma'am.
and then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember, no.
All right, I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
Talking about State's Exhibit 2. Oh, 10:03 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be in, I might be referring you to the wrong exhibit.
Point 1, I believe.
And that was at 4:53. The second warrant was obtained at 4:53. I might not have handed you pen
I
trap.
don't think I have that one.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the affidavit for warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pen trap and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
The only caveat being what I told you before is where you have is a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law in the Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as Pen Trap and Trace.
This one is also listed as S1 on the sticker. So that's going to cause some problem, I suppose.
It's S1 attached to a different motion to suppress.
Well, hopefully we can figure it out when we're looking at the entire record, but
And what I think, Judge, when you are going back and working with your clerk.
my concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it to a stack of documents. That's my concern for this, so.
And I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So we're on the record of what we're looking at.
So Detective Payne, is that the warrant that, that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant.
So, Frank and Infinity, I'm not sure who you're talking about, but if you did an interview and you're coming over here to self-promote your channel, that's all well and good. But I have a very small community, and right now there's 13 people in here, 2 of which I believe are you. So, just letting you know. You're welcome.
See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and/or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
Cracks me up how Thompson just sits there like
What'd you call that,
a
Judge?
bump on a log.
Dash 2.2,
That's dash 2.2.
further delineated by the title, which is related to the pen trap and trace.
On page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction, I see what you mean. Affidavit of Lawrence Mowry is what it says at the top.
Right, and then, but is that actually your
It is, yes, ma'am.
affidavit? And so that was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowry.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker. And it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
It does.
Let's mark that S2.3.
Yeah, I think so too, Miss King, a little bit. Not a good
In the
look.
next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that. Might take us a couple days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
Yes, ma'am.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple.
Yeah, it's going to be in August.
Prior to this case, had
Ms.
you ever
King.
prepared an Apple warrant?
I don't remember.
What was your training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
You know, this judge is thinking, God, this has been a long couple of
Can
days.
you state what that document is?
Appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is the date on it
December 21st.
of 2022?
Correct.
Right, Miss King.
And that letter was not sent by you, right?
No, I do not remember sending this, no.
Well, can you look at
That's not me.
yeah, the top of it is Department of Justice, and the back, page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was
Oh, thank you, Donnie.
executed, there was an
Thank
iPad
you.
that was located
Friday
in one of the
popcorn on
shared living spaces in the home.
me.
And there's a
Popcorn. Thank you for the popcorn, Donnie. Thank you. Here, let me give you some sparkle popcorn. Thank you for the super chat, ma'am. I appreciate it. And I also, just because I'm in the mood here. Oh my God. Thank you, Donnie. I appreciate it, girlfriend.
receipt in his vehicle, in
Very
Kohberger's vehicle,
much.
that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember, no ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar, yeah.
And you mentioned the receipt that was found in his car. Do you recall the date that indicated that an Apple product was purchased?
I do not remember.
Right, I will show you State's Exhibit 1 to the affidavit for search warrant. And I believe it's tabbed, the receipt.
This is State's Exhibit S1, affidavit for search warrant to Apple Inc.
And is 2018 the date?
Yes, ma'am.
Where did you get the form to prepare the Apple warrant?
The form, be more specific?
Correct, well, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so I don't, or I'm gonna have to give them a different exhibit.
Just so I'm clear, are those when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine, I'm looking for the page here. Do you recall that in your affidavit, there's reference that iOS devices can use an iCloud account to back up the iOS device?
Yes, ma'am, that sounds familiar.
And what's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems. Essentially, they back it up to a cloud account. That information is stored not on your device only, but also in a cloud storage area. That's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone?
Essentially, yes.
And do you recall that in the affidavit, you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
D. I'm handing you what's been marked as Exhibit D to, it's Defendant's Exhibit D to the Apple memorandum in support of suppression, and it is it does have a sticker.
Right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant Directed to Apple Inc.
Can you please turn to page 27?
The actual warrant itself that you're,
Yes.
yes, ma'am.
Well, it's, I don't want to answer that as a yes before I look and make sure what this exhibit is.
Want to make sure because my page numbers run out at 25.
It's Exhibit A, and it's to the Apple warrant. It says, so Exhibit D, Apple, at the bottom of that page says page 27, but above that, it says page 23.
Yep, I'm there.
Okay. At the top, it says, on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded
Sorry,
with the
Counselor.
request records.
I'm not there, so can you?
Oh, I'm
give me some
sorry.
direction? Are we looking at state?
Exhibit D?
D?
Yeah, page 27 of my marking bait. So it says Exhibit D dash Apple dash page 27.
On January 27, 2023?
Yes.
All right, go
Yes.
ahead.
On January 27th, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
Okay. And the warrant, the date on this, if you will turn to, let's see. Turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process, to get a warrant on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
I'm handing you Defendant's Exhibit B to the Apple Defendant's Memorandum in Support. It does have a sticker on it.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc. Custodian of Records.
Okay. Detective Payne, on this, there's a certification, this document is a certification of Apple Inc. Custodian of Records. Do you see that?
Yes, ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
Yes, ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know what the legal process would be?
I don't remember what that would have been.
Going back to Exhibit D. Do you have that one in front of you still?
Yes, ma'am.
Can you turn to page 35 of that?
Yep.
On line 4, what does it say?
Warrant was served by Corporal Payne on August 1st, 2023 via law enforcement at apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am, I just want to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and on line 4, it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants that where you actually did service, that you would serve the warrant only?
Yes, ma'am.
And then on Exhibit D, page 37,
Okay.
at the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, B. Kohberger at spartan.northampton.edu, another DSID and Apple ID, Wi-Fi Army owns at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
In terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowry and then S.A. Balance. Those are the folks who knew far more about it than me.
And do you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am, not right now.
Okay, the next warrant we will talk about is Google. I'm handing you what's being marked as Defendants D to the Google memorandum in support of suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC. That as the other documents that were proper are admitted.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowry served the warrant through a portal?
Yes, ma'am.
How did you know that?
Told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data it contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. The Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, defendant's exhibit number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
On this document, under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of Bryan Christopher at gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually Bryan Christopher 1994 at gmail.com?
Oh, that sounds familiar. Yes, ma'am.
Okay, so on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
No, ma'am. Not to my recollection.
Right, that's it for Google. You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, timeframe of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT, and that was about it.
Can you explain what that was, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview, as best I got. So it had your entire SRT that was going to be conducting the operation present.
For the record, SRT is?
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up, yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had.
And so how is that choppy drone feed being communicated to you?
Via cell phone.
So can you explain that? Like, who's the person communicating with you about the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
No, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle used in SWAT operations.
And do you know what role the Bearcat, describe that vehicle again?
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up armored to protect the occupants, being the SWAT operators. And they usually use them as an approach vehicle. So they have a covered location to deploy from.
Is it like a retrofitted military piece of machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery?
Yes, ma'am.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no bigger than, if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
I'm handing you what's been marked as State's Exhibit 5 to the motion to suppress, and it was attached to 119 Lambsden.
All right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State Police. Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
Cross-examination.
We have just a moment, Your Honor.
Oh my God, I cannot wait for this trial. I cannot wait. There's so much information that we have no clue about.
The state doesn't have any clarifications for this witness.
All right, thank you, Detective. You can step down. Actually, can I, if you don't mind, I actually have a question.
Of course.
You testified that you didn't send the affidavits and support search warrants with the warrants themselves to Google, Apple, et cetera. And the persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow-up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
The question was the people that received the evidence, not the people who sent it. So in other words, the police and team that reviewed the evidence, did they have access to it? Not, that wasn't my
Okay,
question.
I didn't hear you. You do
Just to clarify.
You do have a soft voice, and I am losing my hearing. But so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Right, I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay, but not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who, I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So how do, if you don't know who's reviewing something, how would you know that they have access to a search warrant affidavit?
Well, that's the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant within, well, with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct. Yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed?
I believe so, yes.
Okay. I have no further questions.
Follow up from the state on that. All right, thank you, Detective.
Judge, I think we don't need to step away, but I do need a break to organize my documents
Just watching.
for the next witness, who will be Detective Mowry. This calls Detective Mowry.
All right, and Detective Mowry can come and be sworn. One of my staff took the opportunity to take a break. They'll be back in a second, so we'll just get them sworn in and we'll wait for them.
Do you solemnly swear or affirm the testimony you're about to give now before the court is the truth, the whole truth, and nothing but the truth? I do. Thank you.
And I think it's fine if you just want to start with his, if you're going to ask him his background, you can do that.
Good morning.
Morning.
Detective Mowry, could you please state your name and spell your last for the record?
My name is Lawrence Mowry, Mowery.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard, Judge, am I?
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
Do you recall that you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were you co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
All right, I want to talk now about the cell phone, also known as the USB. Do you recognize that? I should say, I'm so sorry, because there are so many cell phones. Bryan Kohberger's cell phone, I want to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those. So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Bryan's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Bryan's cell phone.
Again, I'm asking which search warrant. You're talking about the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized, so it'd be the first.
The Pennsylvania one?
Right.
I do not know.
You're aware that a copy of the phone was made and put on a USB,
Yes.
and then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No,
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So what about is the USB not a physical box of the extraction, or is it all digital?
The USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Normally, in a forensic environment, the device is extracted, that extraction, and then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
The data was placed on a storage device by S.A. Tanzola and provided to me.
Okay, and how did you get the storage device?
I believe it was brought back. I don't recall how I was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay. Judge, this is when you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
Do you have an extra copy of that?
Pardon?
Do you have an extra copy of that?
No, one's, I handed two, right?
Yeah, and just going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there is that extra. I'm assuming you want it for your clerk, so.
My staff attorney,
Yeah,
yes.
yeah. Yeah. Okay, that's a great later.
He's bougie. He's like, I need 2 copies, please.
And just for the record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant.
directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
Because I'm not understanding, that's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber chip information that would be already placed into evidence at the Digital Forensic Lab.
So there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Can you turn to page 24? You see that page?
Yes, ma'am.
And is that a page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises listed as?
155 South View in Moscow, Idaho, in the Forensic Lab. 155 South View, one word.
Does it say USB in that descriptor?
No, ma'am.
Can you turn to page 28? Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by Key in the Computer Forensic Lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
You know, she's
And,
probably
you said
like,
you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information, and they examined it.
And do you know who with the FBI?
No, I do not.
Can you turn to page 27?
dun, dun, dun.
Can you look at page 6? Or not page 6, I'm sorry. Number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that? To
I
put
was,
that?
I was relying on the experts that have worked with or served warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it, and he was the one that informed me that this was the information that we could request.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for?
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done Google warrants before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Bryan Christopher, 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Okay. Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support. You recognize that?
It appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there'd be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Okay. Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay, and that email address associated with the defendant is a college that he attended, right?
Yes.
And so was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with that?
No.
Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believe that the defendant had entered Washington, to become a student nearby the crime scene and just prior to that.
Okay. But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review, so you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Hey, Annie. Good to see you. Hello.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and FBI.
Okay, and were you included in that?
I believe I was.
Okay, and did that include chats,
I believe the word chat means to chat, to talk. Like,
like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple
I don't recall the conversation. This was more specific to the FBI's current investigation, as I stated in my email there for the stalking investigation. I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence, Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
A few questions, Your Honor. Can I stay here?
No.
Okay. Let me move.
Just a few follow-up questions. When you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
Any redirect?
No, Your Honor.
Thank you.
Thank you, Your Honor.
I have no further witnesses.
All right, why don't we take a 10-minute recess, and we'll then pick up.
Okay, let's scooch it on. All right, so this may be where they cut it. And then, yeah, okay. Now I've got part 2. Hold on a minute. Okay. You always catch new things, right, Annie, when you watch replays over? I know. Okay, here we go.
All right, we are back on the record in State v. Kohberger. Defendant is present. Counsel are all present. I'm heard that there are no more witnesses to present by either party. Is that accurate?
Yes.
Yes, Your Honor.
All right, we'll move to argument then. The defense may proceed.
Judge, I'm going to cover several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I question Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday, and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pin, Trap, and Trace, also known as AT&T 2, and the cell phone/USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle. And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All three of these warrants were issued in December 23rd and early January 2023. The two AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T one had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So
Morgana, are you here, ma'am? Morgana. Morgana Banana. Morgana. You guys, Morgana is the sweetest thing. Oh my God. You guys. I have to show you what she sent me. Look at this. Hold on. Look at this, you guys. It's beautiful. It's beautiful. Look. It's a sparkly tumbler from Duncan. Look at the sparkle on that. It's got all the diamonds all over it. Oh my God. Isn't it pretty? Morgana, thank you. She showed one the other day, okay? She showed one the other day in Discord. And oh my goodness, I am pumped. Ooh, and it is stainless steel. Wow, look at that. She showed this the other day in the Discord, and she said she made it, right? Because a big bunch of us are diamond painters, so we all have these pretty little sparkly diamonds all over our house anyway. And we really thought she had made it. But she didn't show us this side. She only showed us this side. Took a picture of it, and she's like, I spent 52 years making this. And we were all like, oh my God, it's beautiful, blah, 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 blah. And then she's like, well, if you really like it, you can find them at Duncan. And we were all like, really? So I looked online, and they were sold out online. They were sold out. And that little cutie patootie went and got me one and sent it. She sent me a message privately a while ago. She's like, have you checked your front porch? I'm like, no. She's like, well, you should have a package. And I'm like, what did you send me? What? I'm super pumped, and it's gorgeous. It is beautiful. It's so pretty. Look how sparkly that thing is. Oh my goodness. Okay. All right. Now that I'm pumped over my sparkly cup, I'm going to go rinse it out and fill it up with something yummy here in a little bit. All right. Cute. This is cute. Thank you, Morgana. Oh, thank you, Morgana. Okay. We'll get back to this. No dishwasher. Right. Yeah, I figured as much. Do not microwave, of course. Hand wash, cold water. Hand wash with cold water only. Alright. Yep. It's beautiful. Okay. She does. You're right. Oh my God. She needs Glitter Man. Look. I'm going to give her like 3 Glitter Men. Hold on. Oh, wait. I got to loop it. Hold on. I'm so excited. It's so pretty. Thank you, Morgana. Isn't it just the funny little sparkly, frilly things that make us happy? Goodness gracious. Glitter. Okay. All right. Yay. Thank you, Morgana. Just in time for the weekend, too. I might have filled this bad boy up with some mom juice tonight. It'll have coffee. Well, I do iced coffee in the morning. And then, yeah, good stuff in the evening. And Morgana, she said my mom said she likes diamond rings personally. Well, yeah, there's that too, but I'm really not a ring wearer. The only ring I would normally wear would be my wedding ring, and I don't even wear it. I don't think I've had my wedding ring on since I had my youngest. I took it off to go into, because I had to have a C-section with her, and they made me take all my jewelry off, and I've never put my ring back on since I had her. Coffee with Bailey's, right? There we go. We'll meet in the middle, right? The responsible drink and the irresponsible drink. Just kind of mash them together. Mine'll fit. And I know where they're at. You want to know where they're at? They're in an Altoid mint can. My diamond ring and band are in an Altoid mint can. Do you want to know why? Because they flew me in there, and they're like, you need to take your jewelry off. And so I had to take my necklace off, and I had to take my rings off. And whenever I gave my husband my rings, he's like, where do you want me to put them? And I was like, I don't know, find something in my purse to throw them in. And he found an Altoid mint can. And he's like, how about this? I was like, yeah, it's fine. And that's where... And I still have the Altoid mint can with the rings in it. It's sort of sentimental now, but anyway, like, yeah, there's a day I had kiddo. Crazy pants, right? All right. Totally random story, but let's go.
Incorporation that would be a remedy for this issue potentially of particularity doesn't exist.
I gotta go show Dale
when
my
the
cup.
warrant,
I'll be right back.
the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof, an oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Paynes, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second broader warrant? The warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23 to 2020, June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Bryan is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowry, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho Pilling case, which is 721 FSUP 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Bryan hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories,
Annie? I know
making the
I'm
productions
married.
bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these.
Ooh, iced coffee with Bailey sounds amazing. I love iced coffee anytime, but that first cup in the morning has to be a hot cup for me. The rest of the day I can have iced coffee, but that first cup I need it to be hot, even in summer.
Detectives that have taken a huge role in this case, who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear. And to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity, those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just piecemeal this, and I can address just those. I can make this pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's positions, these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions, otherwise, state submits, you should deny the motions to suppress for these issues.
Your Honor, I was asked to argue the motion regarding the raid on my client's parents' home, the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case, but it doesn't seem like there's a big argument going on there. So unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right to privacy in the information that we
Bingo,
have
Donnie,
in our
bingo.
Amazon goings about. Why should the state have to have a warrant for that? I thought we set it out pretty well in the briefing, but I think the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that, similar to the one that Professor Kerr made about going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public. He's doing it on his computer, and so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to just briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases, and I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics that they share with other people and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Your Honor, I'd like to address just the third-party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third-party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records. And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government. It's the state's position, and it should be the position of this court, the defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Good morning, Judge. I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania, and then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lambston itself, one of the first things the defendant offers to the court claims there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local
Kiddo
warrants,
just said hi,
Pennsylvania
Kel.
warrants, for the residence, for the defendant's person, and for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because the Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car. So they had lawful process to be where they were, where they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today and the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to, because they are quite incriminating as far as the applicable factors that would justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now, it's clear that the Pennsylvania police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature. Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never an interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those. So those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant. And frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts and the applicable fugitive arrest statutes. And so we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the ITG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was the Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing to question the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument, oral argument.
Thank you.
Thank you, sir.
Logston, any rebuttal?
I think I just rely again on the briefing for the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to
Telling
do.
me facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
there's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that that equates necessarily to the destruction of,
Well, that's not all they knew, but I won't go into the detail in order to preserve, so as that we don't go into those issues.
Thank you, Judge. But beyond that, we're
He was observed in gloves going through his trash and divvying his stuff into a plastic bag to get rid of, apart from his parents' trash, in case his parents' trash got searched. And he was seen on camera or through surveillance through the team that was there taking trash and putting it in neighbors' trash cans outside. So, he wasn't just walking from room to room with a pair of gloves on. There was more to that.
rely on the briefing. Thank you.
Okay. I'll take the motions to suppress under.
So it's not like, because he's trying to say, oh, well, they didn't have to rush in there like they did. They were trying to keep, the judge is saying they didn't want to give him a chance to do anything to any evidence. Obstruction of evidence and whatever you want to call it. I don't know. But yeah,
Ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert's disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon, so.
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
Let me ask a question from a.
Yeah, I'm not sure about. I don't know all the ins and outs of the Brent guy. Is this the Kopaka dude or whatever his last name, the one that took his life or whatever? Ugh. I don't know about any of that. I've heard things, but, I don't know.
I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point. And I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also
said.
have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand from the briefing is respect to that. I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? Let's just say Mr. Kohberger on X date purchased a television, if for some reason that were to be important, and that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon, and that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their
I've slowed it down
expert
a little bit, back to
responses
normal.
based on later discovery or whatever they decide to use.
Instead of 1.25.
That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly. I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I would assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over-disclose those opinions in caution rather than under-disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. That's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not, that you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay? Thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree, and so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplemented, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that, and should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say cast report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox, that's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60-some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect, so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial. And the defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay? All right, well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All rise, please.
All right. So he's basically not saying that they're going to have a Frank's hearing, but it's possible. And just in case, have some dates ready within the next 3 weeks. So I'm assuming that that's a strong possibility. And if that's the case, it's going to be within the next 3 weeks. I mean, I don't know. We will see. We will see. We will see. We will see. All right, you guys, I'm going to get out of here. It is Friday night. I got a pretty cup to go fill up. So I'm going to go do just that. I hope you guys have an amazing weekend. Thank you for spending today with me. Even though we didn't, have any trial coverage in the Natalie Cochran case. This was a great day today in the Kohberger situation. Even though we didn't get a hearing, I just love this judge. Kel, I agree. This judge is awesome. No delays. No delays. You too, Patricia. I hope you have a good weekend. And your mama. I don't know if Miss King is still here or not, but if not, be sure to tell her I said have a good weekend, right? All you guys. Sherry, Kel, right? Yep. Sherry, I hope you have a great weekend. Donnie. Bye, fam. Family. Henny, you have a great weekend too. Is it still racing time for you guys? Is it race time? All right. I love you guys, and I'll see you back on Monday for the Natalie Cochran trial day 7. Does that sound right? I think it's day 7. Anyway. But if you're out and about this weekend, winter stop. Okay. Okie dokie. Yes, happy birthday to QB. If she ever gets in here and sees this, I don't know if she will or not. So, but yeah, happy birthday, QB. If you see this, love you guys. Make sure to hit the thumbs up button before you leave. subscribe if you're new, hit that notification bell, and put a hashtag replay in the comments down below if you're watching on the replay. All right. You guys have a great weekend, and I'll see you back on Monday. Love you. Mean it. Bye.